everyone. And this panel is titled Lions, Tigers, and Billboards. And it's because at the beginning of that song in The Wizard of Oz, Dorothy says, "I don't like this forest. It's dark and creepy in there." And I would say if you poked around Florida's common law, largely because of some poor court decisions from past courts, there are some scary pockets of the common law, and they probably deserve some legislative attention. And so with me today to speak about that are two people who practice in two areas where the common law is a little dark and scary right now. One is Rick Parker. He's with the Butler firm here in Tallahassee, and he primarily focuses on third-party bad faith law. And then Al, and I'm going to mispronounce her name always. Saikali, with Shakardi and Bacon in Miami. Al was probably one of the best, most well-prepared witnesses for the data privacy bill. He came and represented the business community well in committee, given his extensive knowledge of privacy law. And so I'll turn it over to Rick first to talk about his area of law and how it has become a little bit of a three-headed monster due to some interesting court cases.
Okay, thank you, Ashley, and I'll go over some of those. I'm trying to condense this third-party bad faith into an 8-minute presentation, which is admittedly difficult. Third-party insurance, as many of you know, is insurance that protects you against liability to others. The prime example is car insurance. You run into somebody, you cause property damage and bodily injury, then your insurance company has to protect you against that liability. And that includes the duty to defend, which means the insurer has to retain an attorney to defend you against any claims made by the claimants, anybody who was injured as a result of your negligence. That's called the duty to defend. So what is bad faith then? Well, it was first articulated in Florida in 1971 in the Supreme Court case of Thompson versus Commercial Union. There the claimant obtained a verdict that was, or a judgment that was about twice what the policy limits were on the auto policy. And that court allowed the injured party to bring a direct action against the insurance company, even though he's a stranger to the policy. And that really is what started the bad faith slide down the hill in Florida. The obvious result of a finding of bad faith is liability in excess of the policy limits. And where you see this most is low limits cases, auto cases with $10,000 limits, because those are usually staffed by fairly new adjusters, and it's very easy to set up an insurer for bad faith in that instance. It really took off in 1980 with the release of the Supreme Court's decision in Boston Old Colony versus Gutierrez. And I'm going to quote from the case and have a seat and get ready, because this is a pretty big a dose of word salad. An insurer, in handling the defense of claims against its insured, has a duty to use the same degree of care and diligence as a person of ordinary care and prudence should exercise in the management of his own business. For when the insured has surrendered to the insurer all control of the handling of the claim, including all decisions with regard to litigation and settlement, then the insurer must assume a duty to exercise such control and make such decisions in good faith with due regard for the interests of the insured. This good faith duty obligates the insurer to advise the insured of settlement opportunities, to advise as to the probable outcome of the litigation, to warn of the possibility of an excess judgment, and to advise the insured of any steps he might take to avoid same. The insurer must investigate the facts, give fair consideration to a settlement offer that is not unreasonable under the facts, and settle, if possible, where a reasonably prudent person faced with the prospect of paying the total recovery would do so. Now, does that give anybody any idea of what really constitutes bad faith? That is just a bunch of subjective things, and I'm not sure how sophisticated everyone is in terms of law, but it's impossible to get a judge to rule on undisputed facts in a third-party liability case. It's called a summary judgment procedure. You just can't get it because the standards are so ethereal and subjective. So the cases end up going to a jury more often than not, and the insurers, faced with the possibility of paying 3, 4, 10, 20 times their policy limits, generally end up settling the cases. That's what's driving, so much of the increase in premiums in Florida, particularly in the auto context. It also happens in the comprehensive general liability context, policies that insure businesses for slip and falls and things like that. But really, the heart of the matter is auto cases. Some other cases that have affected the mix there's a case called Koblenz versus American Security that held that an insured can enter into a settlement agreement in excess of policy limits with an injured claimant, and the insurer has to prove that the settlement was unreasonable in amount and tainted with bad faith in order to escape liability for that excess judgment. Now, that's just fraught with possibilities for, insureds to do things fraudulently to get themselves out of liability and hang it all on the insurance company. And then in 1991, the Supreme Court muddied the waters further with Powell versus Prudential. That case holds that where liability is clear and damages in excess of policy limits are likely, the insurer has a duty to initiate settlement negotiations. It doesn't say the insurer has to do so within 10 days, doesn't say it has to do so in completed investigation within 30 days. None of that. It just says you have to initiate settlement negotiations. Again, a very subjective standard. And then there are two cases that emanate from the lower courts that have caused a bit of confusion and I think are ripe to be addressed by the legislature this session. They are Farinas versus Florida Farm Bureau. That was a 2003 case. Farinas held that an insurer cannot exhaust its policy limits by settling with some injured claimants and not others. In other words, you have a catastrophic case, 6, 7 people get injured, and you've only got $30,000 in policy limits. What does the insurer do? The best the insurer can do is try and settle the most, the claims that present the greatest exposure. And if you have to leave the other claimants with no recourse, that's what you do. But according to the Farinas court, you can't do that. That's automatically bad faith. And then there's another decision from 2006, Contreras versus U.S. Security. This was a breath of fresh air. That court held that an insurer may settle for limits for one insured, leaving the other exposed to an uncovered liability. The situation was the driver was negligent, and I think the other insured was the owner of the vehicle under the dangerous instrumentality doctrine. The claimant absolutely would not settle with the owner or the driver, but was willing to settle with the owner of the vehicle. So U.S. Security settled the case against the owner and left the driver to his own devices. The Contreras court said that the insurer may do that. So that is certainly a nice ray of sunshine. The final one is Harvey versus Geico. This was 2018. This is another word salad opinion. And this is a quote. An insurer is not absolved of liability simply because it advises its insured of settlement opportunities, the probable outcome of the litigation, and the possibility of an excess judgment, all elements from Gutierrez. Rather, the critical inquiry in a bad faith is whether the insurer diligently and with the same haste and precision as if it were in the insured's shoes worked on the insured's behalf to avoid an excess judgment. Again, does anybody discern an actual rule in there, or is it all something that has to be decided by a jury? Every case would be unique on its facts, so you can never get a summary judgment, and the case always has to go to a jury. So, what do we do? What's the way to fix this? And there are a number of approaches that people have suggested. I have a few of my own. One would be in the context of pre-suit demands for policy limits. Have a deadline that's stated in days. By statute, the insurer must respond within 30 days or 60 days. To an offer for policy limits. There is currently a statute on the books for first-party liability insurance. First party is homeowners, your car insurance where your car gets wrecked and they pay to fix your car. First-party bad faith, it cannot be brought until the a claimant files a civil remedy notice with the Florida Department of Financial Services, and that notice then puts the insurer on notice, and the insurer then has 60 days to investigate the claim and pay the cure, or determine whether it wants to pay the policy limits. That statute could easily be amended to include third-party bad faith within its ambit, and I think that's probably one of the best approaches to it. Another nice goodie would be a codification of the Contreras decision, so that not just in that one district court of appeal, but across the state, it would be okay for insurers to settle with one claimant and not another, or with one insured and not another. So I think that's the way that we need to go in the future, and I think the legislature may be moving in that direction this year.
Hopefully, right now, the rules are that there are no rules, so it would actually be nice to have some rules that everyone on both sides knows how to follow and can follow with ease, and hopefully, I know you're very good at what you do, but without necessarily having to pay a lot of expensive lawyers to kind of figure out what the rules are when you come to find out there really are none, so.
That's it, in a nutshell.
Yeah. Al, I know you've been working on data privacy. There's a number of things maybe happening with breach liability for businesses that are kind of working their way through different court cases. But then we also have this funny thing under the Telecommunications Act about auto dialers. That's also a fun little hangover from 2021. So if you want to talk about that.
Sure, yeah. So good afternoon, everyone. My name is Al Saikali. I chair the privacy and cybersecurity practice at Shook, Hardy & Bacon. I'm in the firm's Miami office. We've got about 30 lawyers in our group nationwide, and all we do is privacy and cybersecurity work. And a increasing amount of that work is for litigation. We're currently handling 250 class action lawsuits throughout the country that are just based on privacy and cybersecurity issues. I'm going to talk to you today about 3 of those issues, and I'll talk to you a little bit about what is the problem, and then what is the way to fix the problem. So start with data breach class action lawsuits. These things are coming up all over the place. So it is unfortunately the reality of doing business these days that a company will suffer a data breach, whether that's the inadvertent sending of information to a third party or a sophisticated cyber attack. These things just unfortunately happen a lot. When it happens, the law requires the company to provide notice to the state regulators that a breach has occurred. And a lot of these state regulators, unfortunately, then take that letter that the company sent to them and put it on their website. Maine does this, California does this. There's a number of states that do it. And if you're a Florida company and you suffer this data breach, you may have to provide notice elsewhere, not just in Florida, because the information you collect is from individuals all throughout the United States. So when you put it on the website, who wants to take a guess at what happens next? Somebody give me a guess. The plaintiff's bar, right? These guys have paralegals that are working for them that check all of these sites on a daily basis. And they look and they see, okay, this company just suffered a data breach down in Florida. We're going to sue them down there as a result of it. And it becomes this race to the courthouse. Who can file the first lawsuit? Because the way the law works is whoever gets in first, you can have a bunch of lawsuits afterwards, but whoever gets through the door first, that's the one that gets to lead. And then everything gets consolidated around that lawsuit. So it's this race to the courthouse steps. And sometimes the regulators disclose a lot of information about the breach. For example, who was the law firm that worked on the underlying incident? And the plaintiff's lawyers are getting pretty savvy. They see, oh, I know that defense firm. They do work for a lot of insurance companies, which tells me that there's probably some cyber insurance here that I can dig into if I sue that company. And unfortunately, that happens. So these lawsuits are getting filed. And the problem is, to something that Rick said, when the lawsuit gets filed, they're really hard to win on motions to dismiss. You can't just file a motion and say, okay, this thing's going to go away, a judge is going to toss it, because there are a lot of factual issues that come up. Unfortunately, it's the nature of a data breach that the company did something that could have done differently that might have prevented the breach from happening. There's like 1 million doors you'd have to close, and it's just impossible to close them all. And so that gets them past the motion to dismiss. So it becomes a financial decision for the insurance company or for the company that gets sued. Do I settle this, or do I fight it? And so the plaintiff's lawyers are making $150,000 to $500,000 on each one of these cases that they file, right? Because that's what they get in the attorney's fees, and they settle the class. You know, you could, as the company that got sued, pay them like maybe $50,000 to go away on that case, but all you buy is a resolution as to that specific plaintiff. You'll find another plaintiff's lawyer will just come forward and file another lawsuit and with a new plaintiff. And the ironic thing behind this is you want to guess how these guys find their clients? It used to be the day, like you guys were talking about, the Turnpike has all these billboards, or you see it on TV. They are now using the entities that they are suing, social media, in order to advertise this. So you'll see sometimes an advertisement on social media saying, you know, were you a customer of so-and-so? If so, you may be entitled to thousands of dollars in damages as a result of a data breach that they suffered. You know, so it's ironic. Now, okay, so that's the problem. How do we fix it? One of the ways to fix it is by creating a safe harbor from liability for these companies. So we have in Florida something called the Florida Information Protection Act, and that's our data breach notification law. It requires you to provide notice, like I was talking about, if you have a data breach. But it also says in there that you have an obligation to adopt reasonable security safeguards if you collect personal information of individuals. So one idea could be, if you substantially comply with the requirements of that law, then you are immune or protected or capped in terms of the liability. That's one approach that you could take. So that's just one of the issues that we're looking at. The second issue that we're looking at is website tracking. This is the hottest issue in data privacy right now, website tracking. What does website tracking mean when I say that? So let's say you're a hospital. Strike that. Let's just say you're Joe Landscaper, right? Joe Landscaper has a website where he wants to advertise to all of his customers. And one of the things that he puts on there is something called session replay technology. Another thing he'll put is a metapixel. And so for session replay, for example, he can see where are people clicking on my website? What are they doing? So that I can offer goods and services that are a little bit more aligned with what my customers want. You know, and with pixels, what that does is, like when Al goes to Joe's website, information about the fact that Al was on the website gets shared with Facebook if Al is a user of Facebook. Now, Al knows, because Facebook discloses, that one of the things that happens is when I travel around the internet, information about me as I visit a website is shared with Facebook. Why? So that when I go back to Facebook, I see advertisements for Joe's Landscaping, right? That's the way business is done these days. They use the social media for this. And so what's been happening now is the plaintiff's bar stumbled upon the way that this works, and they've now filed all of these lawsuits alleging violations of the state wiretap law. Here it's the Florida Security of Communications Act. And why are they doing that? Because these wiretap laws create a private right of action and statutory damages, right? So it means you have the right to sue, and statutory damages is huge for plaintiffs in these privacy cases, because the biggest obstacle that they face is demonstrating that the individual suffered some real harm or some real injury as a result of the thing that's alleged to be bad. Take, for example, Joe's Landscaping, right? So Joe, what is the harm to Al when he goes on Joe's Landscaping and his information, the only information shared with Facebook is the fact that he visited Joe's Landscaping website, right? Like, should I be able to get $1,000 for that? That I didn't know that this was good, and well, arguably I did know because Facebook told me. So this is another thing that's happening, and these things are getting filed all over the places. And it's all based on these statutory damages. There's an easy fix for this as well. One of them would be just changing the Florida Security of Communications Act to make it clear that it's supposed to go towards intercepting people's private conversations with each other. It's not meant to go to a business that I am communicating with, monitoring how am I using the website, right? And so there's a change that you could make to the statute that would say that for regular commercial purposes, this law doesn't apply to that. This law doesn't apply to code, and there's actually federal case law that says something similar. So if you did that, you'd cut off the plaintiff's bar on that front. Now, one other thing you could do on all of these is you could create two-way attorney's fees provisions. Because what you find right now is the plaintiff's lawyers are pursuing claims under statutes that give them the ability to get attorney's fees. But if the business wins, they don't get anything. Like, that to me strikes me as completely unfair, right? And one of the ways in which we defeat some of these lawsuits is they may be brought inadvertently under statutes that allow for my client to also collect attorney's fees if they win. So when I say to the plaintiff's lawyer, you know this consumer protection statute you're bringing it under has a prevailing party attorney's fee provision, not one way. So if we prevail, we're getting attorney's fees against your client, then all of a sudden they get a little bit more serious. So that's another kind of case that's in here is the website tracking. We're seeing a lot of those. I think we've now been hired in 40 in the last 3 months. The last is the Florida Telephone Solicitation Act. As some of you may know, this was amended recently, and it's essentially the equivalent of the TCPA, meaning it applies to unwanted telephone calls and text messages from businesses. The federal law, the TCPA, was recently interpreted by the U.S. Supreme Court in a way that interpreted it very narrow in terms of what is an automated system. The Florida version did not have that interpretation. I understand that there is legislation that may be introduced in this session that will introduce that more narrow interpretation of what it is an automated dialer or an automated system, and Representative Fabrizio, I believe, is part of that effort. And that's going to be really important in dialing back these lawsuits, because we've seen dozens and dozens of these getting filed in Florida. And there's 2 law firms in my home area of Miami, unfortunately, that tend to be bringing these throughout the whole state. And it's a total shakedown, because what they want to do is they file the lawsuit, and they know it's going to be more expensive for you to defend it than to just pay them something. So typically they're looking for like 15, 20 grand and they go away, which that just doesn't strike me as the right thing, right? It can't be that a plaintiff's lawyer just gets to file something, which they have a copy of, right? Like it's just the same thing, just change the name of the company and file it against each different company that they can find in the hope that, it won't be fought, and then instead they just get their $20,000 and they go away. So one of the ways in which that law can be improved as well is, again, by adding a prevailing party attorney's fee provision. Not just that the plaintiff wins, that if the plaintiff wins, they get attorney's fees, but also if the defense wins. Now, the pushback on that is always, yeah, but Al, if you guys won, would you really go collecting attorney's fees against this individual who sued you for tens of thousands of dollars in your attorney's fees? Answer, probably not. But do I want the threat? Yes. Do I want the ability to use that as leverage in negotiation in order to get a quick settlement or in order to get it voluntarily dismissed? Yes, I want that. So that's just another area. And sorry, I've gone way over my time. But those are 3 areas in cybersecurity and privacy that are causing a significant amount of litigation and costs for companies doing business here in Florida.
Great. And the last issue I'll talk about is a subset of premises liability, which is born out of kind of the common law around negligence. And it's something that's actually gotten even increasingly more interesting for me over the last year of working with some affordable housing providers and the like. And what struck me is, I think everyone's familiar with AIF was part of this, FJRI. About a decade ago, there was some reforms to slip and fall cases. The common law had developed in a way that there was basically strict liability for any business where someone slipped and fell. And the standard really needed to be that you have a duty to prevent the preventable, right? If you know that hazards can kind of happen, you need to implement reasonable measures to kind of take care of those and monitor for those. But you shouldn't have a duty to prevent the unpreventable. And so the common law had developed in such a way that anytime anyone got hurt, even if yogurt had been on the floor for 1.5 seconds, a grocery store was getting sued for a slip and fall case. And so the legislature stepped in and said, hey, we're going to make a statute that says it has to be reasonable. We got to rein this in, and we have to give businesses a fighting shot at keeping their businesses safe before we can sue them. This is kind of dovetailed into this area of the law called negligent security, and businesses, as part of their duties under premises liability, also have a duty to prevent people from foreseeable criminal attack. And really the key to any of these cases is foreseeability, and foreseeability is really limited by only the imagination. It is really a creature born completely of common law. It depends on which district court of appeal jurisdiction you're in to determine exactly what foreseeability means. One DCA will say, hey, foreseeability is kind of anything that's happened in a 2-ish mile radius within the last 2 years. And others will go farther. Others will say, hey, you're in a good neighborhood, but you had security guards here. So that means you did foresee something bad happening. And the way this plays out is, for an example like this, you're at an apartment complex and someone gets in a fight with someone they know, and someone gets hurt, and they actually sue the apartment complex and say, hey, you had a duty to prevent foreseeable criminal attack, and this criminal attack was foreseeable. I was assaulted. Doesn't matter it's someone I know or I got in a fight with. It was preventable, and you failed to prevent it, and therefore I will sue you for failure to provide adequate security. And Brewster Beavis actually was driving down the road on North Monroe and alerted me to a billboard that's there that says apartment shootings, ? And I think we both just talked about what a sad commentary on society that billboard really was, because what we knew was the truth behind it was that they were probably going to sue an apartment complex and compound one tragedy with another tragedy, meaning that now people's rent goes up because they're all held to some standard of liability for something that they really had no part in. There's a few firms that do a lot of this plaintiff's work, and there's one firm that actually had a case that they brought against a corner store, and if you've heard me talk about this, I usually have used this example. And someone was shot. It was very sad by someone he knew, but still obviously very sad. But the decedent's family decided to sue the corner store. And they sued the corner store for negligent security, and their entire theory of the case was summed up in this one email they sent out. And they said, we are suing this corner store because this corner store knew this was a bad neighborhood and chose to operate here anyway. And that just violated kind of all of my inner bounds of decency and what our society should be. And so I think, Florida law, Florida common law has gone towards this complete one-sided analysis of anything that is foreseeable, you have a duty to prevent, even though it is kind of by definition unpreventable. And oh, by the way our negligence law works under the comparative fault doctrine is if an apartment complex or a furniture store or a grocery store is sued for failure to provide adequate security, the store can't say, hey, maybe I had a light out in my parking lot, but this person assaulted you. Like this was their fault. The damages that you sustained were really not my fault. And under Florida's comparative fault doctrine, you cannot compare or consider the fault of people who act intentionally. So if someone were to kind of combine in an act of negligence to cause someone's damages, you could consider an apportion fault to them accordingly. But if someone does something intentional, you cannot apportion fault to them. And so what's happening is premises owners are getting 100% of the damages for some of these cases for something that by definition was unpreventable. And so hopefully there will be some sanity. I know a lot of people are talking about it. Affordable housing is an issue that the legislature is working very hard on. And I'm hopeful that there might be some remedies to that. About 20 years ago, convenience stores got really smart. Things like this were happening to them and they were getting sued. They said, hey, like we really want to be safe places for people to come and grab a Gatorade or a bag of chips or whatever they're coming, a prescription. But we are getting sued for things that we cannot prevent. And so they put into law a rebuttable presumption for convenience stores and basically said, hey, if we have this type of illumination outside of our stores, if we have 2 employees working, if we're doing a night shift, if we have a locked cash box and video cameras at points of ingress and egress, then we are going to be presumed not liable unless we haven't done kind of one of these best practices. And so hopefully something like that might be considered for apartment complexes, for other businesses, who knows, but it's just a really interesting standard where we're holding businesses kind of as guarantors of people's safety when life is just really not without risk. And so happy to take any questions. If anyone has any questions. Sure.
Yes, ma'am. No water, white pressure, no mechanism. The same thing happening with the construction industry. Insurance companies you're talking about salt and battery, which is out there. Many of the insurance companies now are excluding the salt and battery. Okay, if somebody gets stuck in the parking lot, your parking lot, where you do it.
Yes, it has been brought to my attention by a number of people in the multifamily residential space that assault and battery coverage is becoming increasingly hard to procure as part of the general commercial liability coverage. And that's really because, insurance companies are really good at math. And they look and they say, if one bad thing happens, similar to something that's happened in this 3-ish mile radius in the last 3 years, or whatever that means, right? Then we're paying for all of it, and we'll probably get a letter of protection on top of it to make it a multiple of 3.
Also, what's happening is that a lot of the insurance companies are excluding weapons. If there's a firearm situation on their property, your policy, there's a chance not to exclude it. So that's one thing which, the insurance companies will try to get out of paying certain things, insuring restaurants and their folks. Like you say, unfortunately, the insurance companies are afraid to go to court because they don't have to go to court. The jury pool is, I think, we're talking about that. There's open rules for the court.
Sure, and this is something I said in the whole context of property insurance, no one is in business to sell less of what they make, right? No one makes money that way, and insurance companies are not in business to sell less of what they make either. And if they are selling less of what actually makes them money, you probably know something is wrong. Well, like Dorothy said, I don't like the forest. It's dark and creepy in here, but when she gets to the wizard, he gives the scarecrow a brain and he gives her a home. So hopefully we can have a better home for businesses, hopefully after this legislative session, where we have a little bit more sanity in the rules that we all abide by. No other questions? All right, thank you.